Today we consider legislation that is at once another flagrant violation of the Constitution and an assault on the health and well-being of young women and their health care providers. Before we start discussing this bill, versions of which we have considered in the 105th, 106th, 107th, 108th, and 109th Congresses, and I presume will have no more success in this Congress, I think it is important to note that this is the 9th time this committee has met in this Congress to assault the reproductive rights of women. The 112th Congress has had just over 200 legislative days so far. If the Republican leadership has put as much effort into helping distressed homeowners or creating jobs or reforming our immigration laws as they have into the war on women, most of our problems might have been solved by now. Instead, we get the swarmed over and facially unconstitutional legislation yet again. Some states have chosen to enact parental notification or consent laws. Some, like mine, have considered this issue and decided it is not good for the welfare of young women and have declined to do so. This bill would substitute the judgment of Congress for the judgment of people who live in states like mine. In fact, even where the young woman's state of residence and the state in which the doctor is located have both decided not to enact such laws, this bill would impose a new federal parental notification law that is more draconian and more unconstitutional than the laws of most states. Perhaps we should just disband our state legislatures and let Washington decide these important family issues for us. If it would spare the rest of us endless speeches about federalism and states' rights, I might be tempted to go along with it. I would just note in this regard that many members of this committee recently voted to allow the laws of some states to preempt the concealed carry firearm laws in other states, including mine. Congress would, in effect, allow any state to nullify our laws and require us to allow any lunatic to walk our streets with a concealed weapon if so much as one other state says they can. As a matter of policy, this bill would place many young women in an impossible situation. In some cases, the young woman may not be able to go to her parents and can turn only to a grandparent, a sibling, or a member of the clergy. Indeed, sometimes the parents may pose a threat to the life and health of the young woman if they learn she is pregnant. That's what happened to Spring Adams, a 13-year-old from Idaho. She was shot to death by her father after he found out she planned to terminate a pregnancy, one he caused by his act of incest. I would commend the authors of the bill for not allowing him to sue in this new version of the bill. It's a step in the right direction from the prior versions of the bill, albeit a small step. This bill also uses a narrow definition of medical emergency that applies only where, end quote, abortion was necessary to save the life of the minor because her life was endangered by a physical disorder, physical injury, or physical illness, including a life-endangering physical condition caused by or arising from the pregnancy itself, close quote. That clearly falls far short of the Supreme Court's requirement that any restriction on the right to choose must have an explicit exception to protect the life or health of the woman. There are many things far short of death that threaten a young woman. She deserves prompt and professional medical care, and the Constitution still protects her right to receive that care. Requiring that young women have their health destroyed is beyond cruel. It is anything but pro-life. I know that I've rankled some of my colleagues in the past by comparing this bill to the fugitive slave law. And I would never suggest that this bill turns young women into slaves, so don't say that I did. I won't even presume to know what Frederick Douglass might think of this bill. But by requiring a young woman or any American to carry the law of their states on their backs as they travel around the country to other states is inimical to our federal system. We have a few laws in New York that I think might benefit the people of other states, but I'm not sure the proponents of this legislation would particularly like it. I know of no law since the Fugitive Slave Act that literally says that you take the law of the state from which you leave when you go to some other state and you use the power of the federal government to enforce the law of the first state in the jurisdiction of the second state. So when she goes from state A to state B, and state B allows abortions perhaps without, let's say without parental notification, this bill says that that's illegal, and that the doctor who performs the abortion in the state where it's perfectly legal to do so without parental notification commits a crime because of the law in the other state. So this bill uses the power of the federal government to export the law of one state to enforce it in another against the public policy of that state. And as I said, I know of no law since the Fugitive Slave Act that attempted to use the power of the federal government in exporting the law of one state to another state. Congress, in any event, should not be tempted to play doctor. It is always bad medicine for women. this unconstitutional and ill-considered legislation will harm young women. But perhaps the intention is to punish young women who desire to have abortions. In fact, that seems to be the intention of a lot of legislation. So maybe it's not ill-considered. Maybe it's simply ill-motivated. I look forward to the testimony of our witnesses and yield back the balance of my time.